Welcome, Professor Ruggeri. The presentation of Professor Stefano Ruggeri from University of Messina is the contribution of international human rights case law to the establishment of fair trial standards in transnational criminal cases, a comparative law analysis of the IHR and the Inter-American Court. Please, Professor, could you please your presentation? Professor Ruggeri, please, you can start.
Oh, first of all, thank you so much for your words and your presentation of my speech. Good morning to everybody. I'm terribly sorry for my delay. The only thing I could say is that I'm Sicilian, and so I was trying to. I'm a little bit justified for my usual delay, but I would like to spend some few words to thank my dear good friend Professor Adam Cesar for this kind invitation to the summer school, which is I feel really honored for this opportunity. And I thought it might be interesting for you to hear something about this very delicate problem to which I dedicate some of my recent studies, a part of my last book, and in the last year one specific contribution. So I will try to begin with some introductory remarks. There is, at least in my country, but I think overall in Europe, and not just in Europe, there has been an growing attention towards comparative law surveys, studies regarding the jurisprudence, international and especially international human rights jurisprudences, and even the standards achieved by the Inter-American organs and the dialogues, the so-called transjudicial dialogues that have been improved, increased, not just between international courts and international courts and constitutional courts within regional areas such as Europe, but also between international courts such as the Inter-American Court of Human Rights and the Strasbourg Court. Compared to this growing attention by scholars of different fields, constitutional law, comparative constitutional law, international law, EU law, of course, there has been a quite scant number, I think, and this is the initial remark I would like to share with you, as far as I know, and relative scant number of studies in the field of transnational criminal justice, and especially in the field of due process and fair trial rights. Now, I tried to give some answer to this question: why such a low number of cases? It is only a question of cases. Of course, especially the Inter-American jurisprudence had this field of the Commission, and the number of cases is not comparable with that of the Strasbourg Court. But it's not a question of number. It is also a question of approach. It is a question of some other factors that have contributed to this result, I think. Maybe we can discuss also later during our question time. On one hand, we have long witnessed traditionally to a consideration, a conception of transnational cases, and especially international cooperation in criminal matters as a sort in terms of administrative accommodation, Rechtshilfetheorie, version to this so-called Rechtshilfe, so legal assistance, mutual administrative legal assistance, rather than Rechtspflegetheory, such a sort of criminal law exercise of criminal powers in the field of cooperation. If we look also at recent cases, the case regarding Turkey, for example, the case of Mamakulov and Abdura Sulovic of 2003 or 4, I think, so relatively recent cases of 15, 16 years ago, we still can observe this consideration of international, or some tools, instruments of international cooperation in criminal matters as a sort of administrative cooperation. And this is really surprising today if we take into consideration that the European courts have, in their respective fields, have increasingly devoted their attention to administrative procedure, to some specific administrative procedure in the framework of Strafrechtspflege. So if we look at this privileged viewpoint of ne bis in idem, both at domestic side and transnational, transborder ne bis in idem, there are a number of relevant administrative procedures which have been considered both by the Strasbourg Court and the Luxembourg Court as penal, as criminal procedures, as relevant for the purposes of Strafrechtspflege. On the other side, on the other hand, I think we cannot overlook the fact that the way, especially international human rights courts have looked at, have examined fair trial, so issues concerned with fair trial violations in domestic cases, was a way that looked at the overall management, let's say, the overall treatment of a criminal process, the way it somehow some number of important, relevant safeguards of fundamental rights have been treated, have been dealt with in a way that some initial deficiencies can be tolerated, let's say so, or can be compensated for at a later stage of the proceeding. If the right to confrontation, for example, this is one of the main differences between our constitutional law model in Italy of the right to confrontation, the accused right to be confronted with the accuser, and the way the European Court has treated it. Because the court has always admitted some alternatives, some subsequent forms of confrontation, but also in absentia proceedings. Now, this overall, this comprehensive way of looking at domestic procedures, of course, does not fit transnational cases, because international cooperation is a tiny part, is only a part of a more complex procedure which involves more than one jurisdiction. And so this raises the delicate question whether and to what extent one jurisdiction can be deemed to be liable for a conduct or an omission and a subsequent stage of the proceeding in another country once the aim of that specific cooperation has been fulfilled, has been satisfied, so that procedure has been finalized. To be honest, if we look at the very old cases in Europe and the jurisprudence of the former European Commission on Human Rights, at the very beginning of the 70s, we can find a very interesting case which highlighted a very modern conception of international cooperation and international law instruments of mutual legal assistance. The question was that the 1959 Convention of Legal Assistance of the Council of Europe, of course, as everybody knows, does not contain specific visions related to the right to examine or have examined prosecutorial witnesses. And the Commission in that case, in 1973, the case X, Y, and Zeta, included the examination of that convention, or linked the examination of that convention with the European Convention on Human Rights. Said that that international law instruments, this was the conclusion at the Commission, which did not share the view of the Austrian government, was not cannot be examined, analyzed in an isolated way, but should be examined in an integrated way with the other international, in the framework of all international law. And a quarter century afterwards, later, the Inter-American Court of Human Rights, in its opinion on the right to information on consular assistance in the framework of the guarantees of due process of law, an advisory opinion of number 16 of 1999, so more than a century, a quarter century afterwards. So 26 years later, after the case, the X, Y, and Zeta case, the court said the same thing. And also in a contentious case of that year, the Villagran Morales versus Guatemala, the Inter-American Court shared the view of a progressive and systematic understanding of international law instruments on one side and international human rights tools, charters on the other side. I must say that if we look at the evolution of Strasbourg case law, a recent case regarding Italy, the case Somoghi versus Italy of 2004, if you want, I could share a document which I drafted with some references, or I can share it with you later during the questions, so that you can have something to discuss. If we look at evolution, the developments that have taken place in Strasbourg case law, it is interesting to note that the court in recent times have somehow involved its jurisprudence compared to that of the former commission. For example, the Somoghi case of 2004, yes, more than 30 years later, that case of 1973, the European Court, the Strasbourg Court, said that it was not its task to interpret or revise the fulfillment of other instruments of international law. Now, starting with these premises, I think we can now try to highlight the specific or the different trends, the different tendencies that can be observed in these two main international human rights jurisprudences, so Inter-American system and the Strasbourg system, in relation to transnational cases. There's cases having a transnational dimension, which is not only a definition which should not only be circumscribed, limited to cases involving requiring the activation of instruments of international legal assistance. So a case can have, of course, a transnational dimension, regardless of whether a specific procedure of international cooperation is required. But anyway, everybody knows the starting case, let's say, so at the end of the 80s, in 89, the case Söring versus United Kingdom. And in that important case, already in that important case, the court highlighted a quite different approach to the examination of violation of human rights and of fair trial rights, because the implications of, by examining the implication of an extradition in terms of Article 3, but also in terms of Article 6 of the Convention, the court limited the possibility of inquiring into foreign law, as everybody knows, to the cases of flagrant denial of a fair hearing. And this approach was maintained, was confirmed a few years later, at the beginning of the 90s, in the case Drotz and Janusek versus Spain, in which, however, the question was a little bit different, because the question at stake was not the risks. This did not concern the risk of a future surrender, international surrender. So the risk of a future violation was not a question of avoiding a violation of a fair trial safeguard. But the question was whether the enforcement of a sentence imposed upon by a foreign authority after a procedure which was deemed to be in contrast with the convention, the enforcement in itself could entail a further violation of the convention. But this case was not a preventive case, but a subsequent case of transnational violation, or let's say subsequent violation. And the case, but regardless of the differences between these two cases, the court invoked a very similar expression, not flagrant denial of a fair hearing, but flagrant denial of justice. This approach, as everybody knows, was clearly in line with the logic of the so-called limited inquiry. It was aimed at limiting the possibility of inquiring into or examining a foreign law and examine the way a foreign authority had carried out a specific procedure. But on close examination, these two requirements, or let's say, the flagrant character, the flagrant nature of a violation is an independent factor from the possibility of a full inquiry or a limited inquiry. And also this requirement of a flagrant denial is not unequivocal. It's very equivocal, very ambiguous. What is flagrant? To what extent? Who says it? Who is competent to say it? And can this evaluation, can this assessment also be challenged? And with what means? How? And why only? But flagrant does flagrant refer to the manifest character of violation of a fair trial, right? Or to the seriousness of that violation? It's not the same, of course. Now, despite this initial and to some extent understandable self-restraint we still were at the time of an advanced and improved phase of mutual legal assistance, but we still had not achieved a more mature stage of that mutual recognition. So it was understandable that the court had such a set restraint in allowing for the possibility of the authority of state aid to inquiring into the way a procedure had been conducted in state B. And it is interesting to know, I think, that at the beginning of last decade, so 2003 or 4, I will look at that, the court had already, I don't know whether we could say abandoned that approach, but anyway, the parties somewhat softened that approach. For example, the case Ilascu and others versus Moldavia and Russia, 2004, there is no trace of such a limitation of flagrant denial of justice, only in cases of fair trial violations. And also in the case I mentioned before, the Mamakulov case versus Turkey, the court used a very ambiguous, reached a very ambiguous conclusion that there was not specific reasons for doubting that the rights which are inherent in a fair trial, and the principle of fair trial, had not been fulfilled. Reasons for doubting, reasonable doubt. Now, if we cross the ocean and go to the Indo-American system, we also we could also witness an evolution of Indo-American jurisprudence, but not in the same direction. On one side, in person to its victim-oriented approach to also the fair trial guarantees, and even in transnational cases, the Indo-American court highlighted the importance of instruments such as extradition for the purpose of avoiding impunity or satisfying the interests of the victim, the agreed partners, and even the next of kin, family members. On the other side, in more recent cases, the Indo-American court, unlike what happened in the Strasbourg system, has relativized the possibility of inquiring as shared a logic of more limited inquiry into foreign law. For example, in the case Wong Ho Wing versus Peru of 2015, 5 years ago, the court reached a very ambiguous conclusion that even extradition procedures must ensure respect for certain minimum safeguards. Certain. Which ones? Minimum. Why minimum? And are the same domestic cases, or can we observe differences in which ones? The court did not clarify it. I know it is difficult to perhaps to follow that and its catchment framework, but it's somehow you have to look at half words, half ambiguous sentences, conclusions which concluded nothing were reiterated in further jurisprudence, but ambiguous concepts. So it's difficult to follow this walk of this jurisprudence, but still we have these indications. We can condition future case law. And it is interesting to note that, in my view, that in the same years of Ilascu, in in which the Strasbourg court, as we said, relativized or let's say departed from the initial approach of declaring responsibility of one country requested country for flagrant denial of justice only in flagrant cases. In those years, 2004, 2005, especially 2005 in the Bosphorus case, the court examined or acknowledged the possibility of a full inquiry into foreign law in cases of discretion of implementation of EU measures which are intended to establish, to introduce standards which are equivalent to those established to those provided for by the European Convention on Human Rights. A question that was posed at the very beginning of this path in the Drotz case was whether a specific international court, despite its patronage, worldwide authority, and can impose upon standards, upon third countries, to just not contracting countries. The court in the Drotz case excluded it in a way that left the door open, let's say so, we can interpret it in this way, the possibility of a more enhanced and more effective inquiry into foreign law in cases of other contracting parties. Anyway, in my view, the question was not posed, was misleading, was not posed in the right way, because the question at stake is not whether a country can be deemed to be viable for a violation in a third country, but is for the conduct or omission, for the behavior of its authorities, for the simple fact that they surrender or decide not to surrender or decide to enforce or not to enforce. So there is a sort of, apart from the violation that took place abroad, in overseas in another country, the question at stake is not whether a third country or not a third country can be obliged to standards posed by another international court, which always examine the conducted authorities of the contracting states. Certainly, if we now focus on specific guarantees, we can confirm this impression of a tendency to soften, to weaken the usual, the ordinary standards posed by or knowledge in domestic cases. For example, I will be very brief about that and then focus perhaps on one. Right to information in extradition procedures. We still have an old case, the case Caprino versus United Kingdom in 1978, in which the court shared a very different approach from that of 73. The right to information of the sought person can be limited only to know that an extradition procedure had been instituted, not to the grounds or the reasons for extradition. And this is absurd, because the right to information of Article 5 of the Convention relates to all cases of deprivation of liberty. And they have this corpus procedure of paragraph 4 of that article relates also to all cases. So a full control of lawfulness of deprivation of freedom should be guaranteed, should be ensured also in cases of extradition. Also, in the Sanchez race versus Switzerland of 1 decade, more almost 2 decades after that, so 86, the court reached a very ambiguous conclusion. Still, in cases, in transnational cases, an adversary procedure in cases of deprivation of liberty, and even surrender procedure should be ensured. But the court said that it is questionable whether there was no reason to believe that applicants present convinced the federal court that they had to be released. So the court acknowledged the right to be heard in person and to make one's voice heard. But at the same time, reached conclusion that if it did not happen, there was not reason to believe that the court had changed its opinion. Very weak conclusion, I would say. Instead, the Inter-American Court has always attached enormous relevance to habeas corpus procedures and to the right to be heard in person, to hear the person, to look at the conditions of that person, even in transnational cases. Perhaps of the relevance and of the constitutional relevance of habeas corpus in the constitutions of several countries in Latin America. And a very interesting question relates to in absentia, so the right to participate, take part personally in the proceedings, and the implications of an in absentia procedure in the framework within a procedure of international cooperation. So what happens if we have to surrender a person who was convicted in absentia, in his absence, or by default? Yeah? Or I had to put it, remand him into custody, although he was not put in the condition of taking part actively in the proceeding and knew nothing about the institution of criminal process against him. Now, everybody knows that traditional instruments of mutual assistance, and it was the Council of Europe Extradition Convention in 1957 said nothing in this regard. And the question was dealt with by the second protocol of 78, which introduced a compromise solution of the so-called conditional surrender. Now, it is interesting, in my view, it is worth observing that if we look at the leading decision concerning in absentia, which was a case regarding Italy, the case Colozza of 84, the court in the middle of the 80s had already established some quality requirements. The court was, the European court was well aware that the conducting a procedure, a trial, criminal trial in absentia can satisfy a public interest. Thus, the impossibility of holding a trial by default may paralyze the conduct of criminal proceedings, may lead to dispersal of evidence, expiry of the time limit for prosecution, and miscarriage of justice. So, therefore, did not exclude a priori at all possibility of in absentia, but established some requirements, quality requirements. The possibility the defendant convicted by default should be granted a retrial with the effective exercise of right to defense, with proper information, or even a subsequent remedy to challenge that conviction, and the possibility of producing new, fresh evidence. This requirement was then adopted by EU legislation in recent times, for example, the directive on the certain aspects of the presumption of innocence and the right to take part personally in the proceedings of 2016. Now, if we compare, if we examine the approach adopted by the European Court to transnational cases and compare it with those requirements established in transnational cases, we can clearly observe a tendency to weaken them, or to, anyway, to depart from that approach. For example, in the case Medenica versus Switzerland, Dr. Medenica had immigrated to US and could not attend the process in Switzerland. A procedure international cooperation had been activated, but a court relativized the right to a retrial and said that the right to a retrial, even if that person was tried and convicted in absentia, is not absolute. It's not absolute. But the person, it is relevant only in the case in which the defense absence was not due to his will to stay away from the proceeding and was not unjustified. So the court somehow offloaded the burden of proof onto the defendant. The defendant has to prove that his absence had a justification and was not his will to stay away from the proceeding. It is a very different approach than that folded into Polozzi case and other cases having another criminal case of criminal proceedings with purely domestic dimension. In the Battisti case, for example, but also somehow in the Medenica, although in the Medenica case versus Switzerland was not said in very clear words. But in the Battisti case, or let's say from the Battisti case on, the court has progressively developed alternative requirements in transnational cases, alternatives to those established in domestic cases. For example, in domestic cases, the court have always pointed out that the defendant can waive his right to be present at trial, but this waiver must be unequivocal, must reflect his willingness, his intention to stay away. In the Medenica already, but especially in Battisti case, the court satisfied itself with an alternative requirement that at least one lawyer of confidence, or two lawyers in that case, had represented a person in court. Now, the fact that my lawyer is present in court does not demonstrate anything, does not demonstrate my unequivocal intention to waive my right to be present in person, follow my criminal trial in person. But the court, rejecting the decision of the Conseil d'État in the Battisti case versus France, declared the complaint inadmissible by highlighting the importance of the presentation in court by the defense lawyers, which is on close examination a requirement, which is a conclusion which does not even satisfy the requirement of fulfillment of minimum defense rights established by the second protocol to the extradition convention, the second protocol of 1978, because minimum defense rights is the requirement is not necessary to refer only to legal assistance, to assistance by a lawyer. A further transnational case, which regarded my country, was very debated in my country, was the FCB, the case Franco-Catberro, the Catberro case, which was dealt with by the court on two occasions, in 91 and then in 2008. In 91, the judgment, Franco-Catberro, in that case, the court highlighted also the importance to examine the conduct to the competent authorities, whether the authorities demonstrated also made their best to inform the sought person of the existence of the institution of a procedure against them. Now, the court, Mr. Captero then returned to Italy and raised a further question in the last decade. It was interesting because in the decision of the court intervened in a period of a reform, drastic reform of this problematic issue in Italy. The question was whether the defendant, or let's say whether a violation of the convention, a conviction in absentia without the requirements established by the court, can be enforced in another country. So whether the enforcement in itself of a conviction of a sentence produced in absentia and declared not to be in line with the convention gives rise also to further violation, to a further infringement on the convention. Now, the court in the case Captero 2008 also declared the case inadmissible because of that reform 2005 in Italy, which broadened the way of lodging a complaint to obtain for the defendant to be released from the effects of the time to lodge an appeal against a conviction already final. So, complaint to be released by effects of time to challenge to lodge an appeal against that conviction. And the court, of course, tried to demonstrate an interest in not enhancing, let's say, the tension between the Italian government and the contentious, this long contentious with Strasbourg regarding in absentia procedures. And so said that Italy had made its faults and that the reform of 2005 could achieve with a sufficient degree of legal certainty the opportunity to go before a court and defend himself in a new set of proceedings. This conclusion was certainly wrong because the Italian reform, legislative reform of 2005 granted the defendant convicted in absentia, by default, the possibility of a late appeal, let's say so, to be released from the effects of time to lodge an appeal. But then in that appeal, that defendant had strong limitations to produce exculpatory evidence. Instead, as we said, the court in the Colozza case and in further subsequent jurisprudence in the 80s and in the 90s had reiterated in domestic cases that the retrial must guarantee the possibility of producing new evidence, fresh evidence. Now, certainly, I would like to spend some words on very famous phenomenon and some few cases which are very known, such as the Meloni case. From the viewpoint of this analysis, it is interesting to know that precisely the Battisti approach, 2006, certainly conditioned the way in which the framework decision of European arrest warrant was amended in 2009, and the way the case of Mr. Meloni was dealt with, was examined by the court by the Luxembourg court in 2013. In other words, perhaps the message left by the Battisti case was that a low-profile interpretation of that requirement of representation in court by a lawyer that legal assistance can substitute, can fulfill all the minimum defense rights, let's say even replacing the traditional requirement of unequivocal waiver. Everybody knows that the Maloney case had represented a point of confrontation of two very different ways of looking at the relationship between EU international law, EU law, international law, and constitutional law. Confrontation with Spanish Constitutional Court, and the closed, let's say, self-referential view shared by the Luxembourg court by pointing out that the fulfillment of the requirements established by the European arrest warrant legislation must be applied in a uniform way. So the requirement of uniform application led at that time to a one-side supremacy of EU law over constitutional law. And as many scholars, many colleagues have said, I also tried to point it out in various articles, this also led to weakening the principle of highest protection of human rights established also by EU primary law, by the EU fundamental rights, and the principle of legal diversity, pluralism in Europe. But anyway, from the viewpoint of the present discussion, it is interesting to know that the merits of the conclusion reached by the Luxembourg court were certainly in line with the conclusions reached by the Strasbourg court some few years earlier in the Battisti case. But it is questionable. It is still questionable that those requirements were in line not only with Spanish constitutional law and maybe the constitutional law of other European countries, but also with international law, international human rights law, with international jurisprudence of the same at the very European Court of Human Rights. Because unlike what the court said, the presentation in court by a lawyer cannot entail, cannot reflect, cannot demonstrate the free, informed decision of the sought person to be to stay away, not to take part personally in the proceeding, even when international cooperation is later activated. Yes. I personally, let's say most colleagues have interpreted the response of the Spanish Constitutional Court 2014 as a demonstration that force can pay, that approach of the Luxembourg court achieved its goal. And effectively, the Spanish Constitutional Court made a step backwards. At the beginning, had invoked the principle of the right to effective judicial protection, Article 24 of Spanish Constitution, and then it shared the Luxembourg's view of a uniform application of EU law standards. But if we look at that response, the late response, 2014, the Spanish Constitutional Court, maybe we can observe underlines the intention to put in the light, to highlight the deficiencies of the European Court of Justice in terms of not consistency, of inconsistency with the clear indications of EU legislation, that is, the intention to be consistent with the case law of European Court of Human Rights, because it is clear that the existence of the appointment of a lawyer does not demonstrate an informed waiver of the right to personal participation. As Professor Böse, Martin Böse from Bonn University has pointed out very clearly, and I fully share his view, a more effective solution might have been that of requiring a competent authority to inform the person of the implications of participating, not participating in court. There are some particular powers which can be some decisions which lie in the hands of the defendant in person. So the lawyer is not entitled, in general terms, to make those decisions. And so the person should be informed of this implication, should make by waiving his right to take part in the proceedings personally, should be put in a condition to make an informed decision. And a similar solution had been reached in the framework decision 64/2010 on the right of interpretation and translation in criminal proceedings. So it's not will not be impossible to amend the European arrest warrant framework decision in that direction, I think. And anyway, the Spanish Constitutional Court somehow provoked or aimed at provoking reaction by other courts. And this happened because 1 year later, 2015, German Federal Constitutional Court, Bundesverfassungsgericht, in December 2015, invoked in a very similar case, invoked the principle of Verfassungsidentität, the principle of personal criminal liability, as from a very interesting procedure law viewpoint, invoking the constitutional identity, so the Verfassungsidentität, to justify the not surrender of a person sought in that direction. But also, even if the Luxembourg Court does not return to this topic, we have surely witnessed a tendency to an increasing attention towards constitutional standards in the Aragnosi case, for example, and to reinforce, to strengthen some fair trial rights in cases with a transnational dimension, such as the Kovaci case. There was a penal order procedure, and some other, and in relation to in other in absentia and inaudito reo procedures, which ordinarily do not provide for the defendant's involvement. Finally, I would like to say just a few words on a tendency, a very interesting trend, which a good friend of mine, a professor of constitutional law, Professor Alexei Julio Estrada, had highlighted in relation to the inter-American jurisprudence concerning another important fair trial right, which is the right to confrontation. We saw that at the very beginning, the former European Commission of Human Rights had shared a modern view of international law instruments which must be interpreted systematically and not as isolated legal tools. It is noteworthy, in my view, that the Inter-American Court has, in the last 15 years, tried to broaden the scope of some fair trial rights, and specifically the right to confrontation, adapting it to its victim-oriented approach, as we said before. So it also restructured somehow some typical fundamental rights which have been acknowledged by the Pacto San Jose, by the American Convention on Human Rights, to the person accused in criminal proceedings, and it attempted to extend them to other individuals involved in a criminal trial, particularly the victim. For example, this approach was confirmed by the court in relation to the Colombian so-called process of justice and peace, which led to a huge process of the mobilization of heads of parliamentary leaders and special processes, proceedings carried out against them, but it also led to the extradition of leaders to US. And precisely in this regard, the Colombian Supreme Court had already pointed out the risk of extradition, which could frustrate the interest in justice and peace and satisfaction, satisfying their claims for justice and by the victims and their family members. And the Inter-American Court shared this approach in the so-called Ituango massacres versus Colombia case, 2006, I'm not wrong. And then it followed the same approach in its monitoring jurisprudence 2009, 2013, by pointing out the risk of extradition in terms of limitations for the agreed parties to examine, to be present at the questioning of paramilitary leaders abroad, and to be confronted with them. It is quite interesting because if we look at the traditional way of traditional conception of the right confrontation, in US constitutional law and also in international human rights charters, we always think at the defendant's right, the accused's right to be the right of the accused to be confronted with accuser, not the right to the victim to be confronted with the perpetrator. Now, I think that the analysis of this factual framework, this allows us to highlight one side to reach some conclusions, which of course are very provisional. To go on one side, we certainly have, we can certainly say that the activation of transnational procedures set enormous challenges for the competent authorities of the both countries, but also put the individuals involved in a particularly vulnerable situation. Notwithstanding that, a comparison between international human rights jurisprudences does not lead to clear indications, but certainly allows us to observe some clear tendencies, clear differences, the clear attempt to distinguish the traditional treatment, the traditional approach followed in purely domestic cases, in one direction or in another direction. Of course, international courts the evolution of international jurisprudences does not follow a uniform path. There is a very interesting article of a colleague of mine, Professor Massimo Vogliotti, almost 20 years ago, who wrote about the flu logic, so the fluctuant logic of the European Court of Human Rights. If we look at the inter-systemic and trans-judicial relationships between courts, it would be quite impossible to draw a linear path. So the path is always so. It is questionable whether this path was always intended to strengthen, was always in line with the acknowledgement of that vulnerable position of the individuals involved in transnational cases. Not just defendants and victims, but also witnesses, third parties, suspicionless third parties. I think the comparison with between two judicial systems, Indo-American and Strasbourg, on these two main systems, and also the relations within our regional areas, the relationship which have evolved among the Strasbourg system of protection of human rights, the Luxembourg one, and the mutual, and the evolution of the relations with domestic, especially constitutional case law. But I think that a look at this transjudicial dialogues allows us to expand the potential, the incredible potential of statutory international law instruments, which are, and I'm very keen to share the opinion of Professor de Matute, a Mexican colleague, which are alive, which need a progressive, systematic interpretation in light of this main aim, the need to constant improvement in the path of protection of the most precious rights of the person who suffer or are involved in such delicate procedures.